As it was said, my name is Hannes Latzel. I work as a legal counsel for SCAI in the Zurich office. I was asked to introduce to you SCAI in the Swiss rules today, and of course I hereby gladly accede to this request. So what will I talk about today? First, I will talk about SCAI, the arbitration institution itself, with its history and its structure and its services. And then in a second part, I will talk about the actual administration of the arbitration cases by the court and with the help of the Secretariat. So first, to the institution and its services, the history of SCAI. As a long-standing tradition, the Chambers of Commerce in Switzerland have been providing arbitration services and appointing experts upon request to assist businesses in resolving their dispute. So 3 of the Swiss Chambers of Commerce, the one from Geneva, Zurich, and Basel, are even among the world's very first providers of international commercial arbitration services. The precursor of the Basel Chamber of Commerce was the first in Switzerland to publish its own arbitration rules in 1869, followed by the Zurich Chamber of Commerce, which established its first commercial arbitration court in 1911. And since 1980, most of the other Swiss chambers of commerce started publishing their own international arbitration rules too. So during the 1990s, it was suggested that the chambers of commerce in Switzerland consider creating a unified set of rules for international arbitration services that would be provided jointly by all the Swiss chambers of commerce. And this then led to the drafting of the unified arbitration rules that were launched in 2004, the Swiss rules. The Swiss rules were drafted by world-leading experts in international arbitration in order to reflect the modern practice and cutting-edge law in this field, and to really provide dispute resolution services to companies based everywhere in the world. In 2012, the Swiss rules were revised to be on par with the latest practice in international arbitration. And in 2019, there was a revision of the Swiss rules of mediation in this regard. Today, SCAI administers about 80 to 100 arbitration cases per year, 90% of which are international, meaning that at least one party does not have its seat in Switzerland. And so it is clear that most of these cases, the vast majority of our cases, are highly international and not domestic. About 43% of our cases are expedited proceedings, and about 53% of our cases are ordinary proceedings, meaning that the tribunal is not set a deadline by the arbitration court to issue an award. Now, to the structure of SCAI. SCAI altogether is an association of 8 Swiss chambers of commerce. The members are the Chamber of Commerce Zurich, Lausanne, Lucerne, Lugano, Neuchâtel, Basel, Bern, and Geneva. The legal form of SCAI is an association, a non-profit association. And next to the involvement of these chambers, in fall 2020, it was announced that the mentioned Chambers of Commerce and the Swiss Arbitration Association will join forces in administering arbitrations and mediations under the Swiss rules. As you can see here in the red bubble, one organ of SCAI is the arbitration court, and the actual administration of the arbitration cases is handled by the court with the help of the Secretariat. The arbitration court consists of 26 members, which are all highly regarded arbitration lawyers, and most of which are based in Switzerland. Another part of the arbitration court is the court special committee. It consists of 9 more experienced court members, and the court special committee has to decide on special issues, such as if a party requests the consolidation of a case, or if the the case arises that a party challenges an arbitrator, in such a case, the court special committee has to decide. Another issue which oftentimes arises is when the parties have not agreed on a seat for the arbitration, if it's not mentioned in the arbitration clause, or afterwards the parties cannot agree on a seat, it is for the court special committee to determine a seat of the arbitration. Here you can see the SCAI core team. The gentleman in the second row, the fourth from the left, is Mr. Xavier Favrebul. He is the new president of the arbitration court. He's a partner at a law firm in Lenzen-Stählin in Geneva, and he is the head of the arbitration department there. Most of the other people you can see here in this picture are also court members. You probably are, if you're interested in arbitration, you know most of them, as they are all esteemed arbitration practitioners. And in the bottom row, you see on the left also some members of the Secretariat of the court, which is assisting the arbitration court in administering the cases. So the starting point of a SCAI arbitration is, of course, the implementation of a clause that refers to SCAI into the contract between the parties. So SCAI offers model clauses with which the parties can choose where the seat of a possible arbitration will be, what the language of the proceedings will be, and if the tribunal shall be a 3-member or a 1-member tribunal. For parties that want to have more flexibility, there are also customizable arbitration clauses that allow parties to determine special questions before the dispute arises, such as deadlines for the filing of the statement of claim, which normally is just set by the tribunal in each specific case, but it is of course open for the parties to predetermine this in an arbitration clause. If they want to, they can forego already before the dispute arises hearings, or for example, they can already opt into the expedited proceedings, irrespective of the possible amount in dispute of a potential arbitration. Moreover, the parties can already in the arbitration clause set a shorter than usual deadline for the constitution of the arbitral tribunal, if time really is of essence. Okay, now let's move to the second part of this presentation, the actual administration of arbitration cases under the Swiss rules. So it is the credo of SCAI really to provide light administration of its arbitration cases and not to interfere too much. For example, SCAI only checks the costs of the award, such as the fees and administrative fees, and not really it doesn't scrutinize the contents, the legal contents of an award other than the cost section, unlike other institutions do. Furthermore, our team helps the parties and the arbitrators to actively monitor deadlines and other such tasks. And we help, for example, the tribunal with the administration of deposits, so the funds for the arbitration, for the fees and administrative costs. Now, what does a typical SCAI arbitration or SCAI procedure look like? Normally, in the beginning, there's of course the need for a party that is willing to start a dispute or start an arbitration against the other party. The arbitration is typically initiated by the claimant when he files the notice of arbitration to SCAI, which will then forward this document to the respondent. And if the party the respondent then has a 30-day time limit to answer to the notice of arbitration, and then the court continues with the constitution of the tribunal. If, for example, both parties want a 3-member tribunal, each party can designate a person which should then be a co-arbitrator. Especially in very large cases with high amount in disputes, it can occur that one party then objects to the confirmation of the opposing side's arbitrator, as they deem this very arbitrator or this candidate to be not independent and not impartial. In such a case, as I have mentioned before, it is for the court special committee to really scrutinize the situation and to decide whether this arbitrator can be confirmed or not. The same holds true, for example, if tribunal is challenged or a member of the tribunal is directly challenged after it was confirmed by the court, then the court special committee has to decide if this arbitrator is removed or not. Another typical thing or typical issue that arises is in cases where there is a sole arbitrator that needs to decide on the case and the parties cannot jointly designate an arbitrator. Most of the times the parties are set a 30-day time limit to jointly designate someone, but it oftentimes occurs that this is not possible. And in such a case, it is for the court then to appoint a person, the right person for this case. And when deciding on such an issue, the court takes into account parameters such as the amount in dispute of the case. So we really, the Secretariat is also involved. We try to help to find a candidate that is suitable. For example, if the amount in dispute is very high, it goes without saying that the candidate needs to be more senior and more experienced. But we also look into the applicable law to the case, the seat of the arbitration, and also look into topics such as diversity and such things. Once the tribunal is constituted, the actual arbitration starts and the arbitral tribunal can ask the party to make filings and such as the statement of claim and the statement of defense. And then most of the times in ordinary proceedings, there is a hearing. And after the hearing, there is the arbitral award result of the proceedings, which will then be scrutinized by SCAI with regard to the cost section. You can see the involvements of the different players in the arbitration. In the beginning, it's just the parties, then it's SCAI, the court with its secretariat that helps with the constitution of the tribunal and dealing with certain issues pre-constitution. And after the constitution, it is the tribunal that has the power to decide. So some of the main issues dealt with by the court and the secretariat are, for example, pathological clauses. For example, if an institution is unclear in the clause, or if some rules are wrongly spelled, if the reference is not quite clear, or if there even is the question if this really is manifestly no agreement to arbitrate, the court, for example, has to decide, is the threshold even met in this case that SCAI administers this case? And most of the times it is met, but in situations where a clause is extremely unclear and it's not even clear if this threshold for an arbitration clause is met, the court can object to administer the case altogether. As mentioned, another issue is the challenge of arbitrators or the appointment of arbitrators. Another typical issue is the amount the number of arbitrators in the clause. For example, if there is no number mentioned by the parties, the court has to look into the case and decide if a one-member tribunal or a three-member tribunal should decide on the case. Here we take into account what the amount in dispute is. Most of the times, I would say if the amount in dispute is lower than 3 million, most of the times the court decides that a one-member tribunal will decide. If the amount of dispute is higher, also taking into account the complexity of the case, a three-member tribunal is set into place. Already I have mentioned that in the end of the proceedings, there is the cost control according to Article 38 and Appendix B of the Swiss rules. Here we mostly look at the fees of the arbitrators, and we take into account what the hourly rate of an arbitrator is, what the actual work rendered is, what the complexity of the case was, and then the court renders a decision either in approving or not approving the cost section. Here I can say from my personal experience in the Zurich office, in the vast majority of the cases, the cost sections are in line with our rules, and the court does not really need to interfere. Very few cases I have seen where really we had to inform the arbitrator, for example, that his fees are excessive and that he needs to reduce them in order to have a more fair balance of fees. Here you can also see in detail some bubbles mentioning special issues of the arbitration. As I mentioned, the request for consolidation is something that arises sometimes where a similar case is filed in a short amount of time. The parties might wish, for the sake of efficiency, that this case is handled together. For example, last fall we had a case where an Italian claimant was suing a Chinese respondent on 1st of November, and on the 3rd of November, it was vice versa, the Chinese respondent filing a claim against the Italian respondent. And in such cases where the amount in dispute is very similar, the parties are the same, the arbitration agreements are the same, it really makes sense to consolidate such cases for the sake of efficiency. And this was also done in this case. So these two cases are now registered under one and on a single case. Another thing that the Secretariat, of course, does is the monitoring of the fees and the registration fees. For example, you see on the left bottom bubble there, the counterclaim. If a party files a counterclaim, there is a registration fee to be paid. And in such cases, it is for the Secretariat to monitor if these costs are paid or not. Should, for example, a respondent file a counterclaim and not pay the registration fee, the tribunal is ordered not to proceed in deciding on such a counterclaim. Lastly, under the Swiss rules, speed, quality, and reasonable costs are core principles. And here you can see that our proceedings most of the times are very fast, or they are done quite quickly. Emergency relief proceedings, meaning emergency cases, are typically over after 15 days. Expedited procedures are on average done after 6 months and 13 days. And ordinary procedures are normally, on an average case, already over after 11 months, so less than a year, and the dispute is already decided. And given there is no challenge before the Swiss Supreme Court against the award, such a decision can already be made in less than a year, and the parties have their decision. So that was my presentation about SCAI. I would really like to thank you for your attention. It has been a pleasure. I have, of course, not touched on every subject, but if there's any question, I would gladly dig deeper into some issue and give an answer to this regard. Thank you very much for your attention.
Maybe procedurally, you can ask your questions simply by unmuting yourself, or you can also put them in the chat to as a public message. Then we should be able to see your questions. So maybe give you a bit more time to do that. Maybe in the meantime, I could ask now also in the moot, we have seen that this pandemic has had a big impact on arbitration in general, so dispute resolution much broader. What was the impact on you in your position at SCAI? Or did you see any significant differences?
So I would say, first of all, I could observe that in most cases, there was not really that much of a delay. Parties and the tribunal, they have shifted quite quickly to virtual hearings in some situations. And I've seen really that the cases, they went on quite efficiently still. What I've seen also that there has been disputes between parties if a hearing shall be done in a virtual format or if it should be waited until it can be done in a normal format. But I really could observe that efficiency really was held up high still despite the pandemic, and the practitioners really, they shifted gears quite fast and switched successfully to virtual hearings. And I have really not observed any issues in this regard.
Okay, thank you very much. I see also via the chat we have now gotten a question.
So unless there is not made a new claim until against a party that needs to be joined, there's not really an additional registration fee. Normally, only if there's a counterclaim being made, an additional one, the tribunal would notify then the Secretariat, and in turn the Secretariat would ask this party to pay this registration fee, and only then the case can continue with regard to this counterclaim or a set of defense.
But there don't seem to be any further questions. So I would like to thank you very much, Hannes, again for this insight into this world we usually don't get to see in the moot, but that still plays an important role. It was very interesting insight into this aspect of the moot.
Thank you very much for having me.
You're very welcome. And we will now have another presentation on witness examination.